So since we have quite a lot to cover, I'll get down to it straight away, and I would advise you, if you have it, to follow the handout which I sent on the jurisdiction agreements. I'll concentrate mainly on Article 25 of the Brussels I regulation. If time permits, I'll say a little bit at the end about both the relationship with the Lugano Convention and also with the Hague Choice of Court Convention, all of which may be relevant in the given case. So let's start then with Article 25 of the regulation, which provides essentially that unless a matter falls within the scope of Article 24, where there is exclusive jurisdiction, then the parties may agree to confer jurisdiction on the courts of a particular member state. Now, this is obviously an expression of party will, and the parties are given a good deal of freedom as to the court which they can choose. In order to ensure, however, that the parties are genuinely in agreement, the legislature has set out a number of formal conditions, the purpose of which is to ensure that there genuinely is consensus. I'll say also a little word about the issue of conferring jurisdiction when the matter falls within one of the heads of protective jurisdiction, with insurance contracts, employment contracts and consumers, which is not completely taken outside the scope of Article 25, but is nevertheless subject to various limitations. Now, before the Court of Justice, the court, of course, has always held, and it's been something of a mantra right from the word go, that the basic rule of jurisdiction under the Brussels I regulation, and indeed its predecessors, is the rule contained in Article 4. And the court has always said that any other rules are derogations and hence must be interpreted restrictively. At the same time, party autonomy is also one of the leading principles of the regulation. So what the court is essentially trying to do is to say, okay, you can confer jurisdiction on any court you like, but we must really be sure that you mean it, and that it's not being, and that the jurisdiction agreement isn't being inserted surreptitiously by one party, where the other party is not really aware of the agreement, the so-called agreement, being inserted. And Article 25 is the successor of what was Article 23 under Regulation 44/2001 and Article 17 of the old Brussels Convention. So some of the old case law will still be relevant. There wasn't a kind of tabula rasa when the new Brussels I regulation came into force. So let's go through the salient points. The first point, which for the first time is made explicit in the body of the regulation, is in Article 25, paragraph 4, where it's stated clearly that, paragraph 5, I beg your pardon, where it said that an agreement conferring jurisdiction which forms part of a contract is independent of the contract, a normal principle of private international law that an arbitration clause or a jurisdiction clause is a separate agreement, and that therefore an attack on the contract is not necessarily sufficient to attack the jurisdiction agreement. The parties have a lot of freedom to confer jurisdiction on a court to settle disputes in connection with a particular legal relationship, and courts in member states cannot add any extra conditions. And in particular, there is no requirement that the chosen court have any objective connection with the dispute between the parties. They may agree on a neutral forum because neither of them wants to go before the courts of the other party, so they may choose a neutral forum. And quite often, of course, in chains of contracts where the parties may have chosen English law, they also want English jurisdiction. Quite how that will pan out after the UK leaves is a different matter, but we'll return to that later in the context of the Hague Choice of Court Convention. So it may be that the chosen court has no link with the dispute and therefore would not have jurisdiction under the regulation in the absence of the jurisdiction agreement. Or it may be that the chosen court would have jurisdiction, perhaps concurrent jurisdiction, and all the parties are doing is, with the jurisdiction agreement, is to make that jurisdiction exclusive. So if you have a contract between a French and a German party, and the interplay of Article 4 and Article 7 might designate either a German court or a French court, the parties can say in advance the German court will have jurisdiction over the matter. Another point which has been introduced by the new Brussels I regulation is that there is no requirement that either party be domiciled in a member state. So even if parties, both of which are domiciled in a non-member state, choose a court in a member state, then that court is obliged to accept jurisdiction, and of course other courts are obliged to decline jurisdiction. So the only real requirement is that the court actually be in a member state. Now, under the old law, if the parties chose for example, a court in Germany, and one of the parties then brought an action in Italy, this would trigger off the lis pendens rules, and if the party then brought an action in the chosen forum, that forum, being the second seized, would have to stay proceedings until the court in the first member state, the wrongly seized court, had decided whether or not it had jurisdiction. This was decided in the very criticised Gasser and Missat decision from 2002, but this has now been reversed by Regulation 1215 of 2012, in particular with Article 31.2. So you need to read this in conjunction with Article 25, because this says, Article 31.2 says that if one of the parties has chosen a court other than the court which is designated, then the wrongly seized court must stay its proceedings until the designated court has determined whether or not it has jurisdiction. So this is one of the changes brought about by Article 25, and it, in a sense, it elevates the status of the jurisdiction agreement. However, if a court does wrongly take jurisdiction in defiance of a jurisdiction agreement, then that is not a ground for impugning the judgment of the wrongly seized court. So despite the fact that Article 25 does create a kind of exclusive jurisdiction, it's not a ground for impugning the judgment if the court that's seized ignores Article 25. Now, we have a number of caveats when deciding whether a jurisdiction agreement can be valid. As I said at first, the big carve-out, if you like, from the scope of Article 25 rather, is matters falling within the scope of Article 24. That is to say, exclusive jurisdiction. So, for example, if the dispute concerns right in rem in Germany, the parties may not validly agree to confer jurisdiction on the courts of another member state. Then, secondly, we have also to look at Articles 15, 19 and 23 of the regulation, which relate to the special regimes of jurisdiction to protect weaker parties, that is to say, policyholders with regard to insurance contracts, employees and consumers. And if we look, for example, at Article 19 of the regulation, which concerns jurisdiction and consumer contracts, which deliberately favours the consumer, Article 19 specifically says that the provisions of this section may be departed from only by an agreement either entered into after the dispute has arisen, gives an extra head of jurisdiction to the consumers, and then a very specific exception. So this is something, if you're faced with a jurisdiction agreement, you would also have to ask if it is in compliance with one of these protective heads of jurisdiction. As I say, it doesn't outlaw it completely, but there is a cross-reference in Article 25.3 which refers to Articles 15, 19 or 23. And then finally, and perhaps somewhat paradoxically, Article 26 can prevail over Article 25. That is to say, if the parties by agreement have conferred jurisdiction on the courts of, say, Belgium, and one of the parties then brings an action in the courts of France, in principle, French courts don't have jurisdiction. However, if the defendant makes an appearance, enters an appearance before the French court and doesn't challenge the jurisdiction of the French court, then he is treated as having accepted the jurisdiction of that court. Now, this is the case in any type of situation if the chosen court doesn't have jurisdiction at all, and it's also been held by the court to apply where the courts of another member state have jurisdiction, but the defendant is assumed to have waived his objection if he enters an appearance without challenging the jurisdiction. So in other words, it's not for the judge of what is the wrongly seized court to raise the matter of his own motion. It's up to the defendant to challenge the jurisdiction. So let's look at some of the more recent judgments on the formal conditions. As I've said before, the purpose of the formal conditions of Article 25, which you can find in paragraph 1, points A, B and C, as the court has very often said, is simply to ensure that there is a genuine agreement between the parties. And but of course, in practice, if the contract is concluded subject to the general terms and conditions of one party, then you can't be absolutely sure that the other party has actually read those terms and conditions. But so the court has had to grapple with this problem. You can never be sure that the parties that there is genuine consensus ad idem. All you can require really is that the one party has taken reasonable steps to apprise the other party of the existence of the jurisdiction clause. In the early days, the court was a little bit demanding in what it expected, but in more recent years, it's kind of accepted the parties will make jurisdiction agreements, and they don't require one party to sit the other party down and point to the jurisdiction clause. They simply require reasonable conduct. So, as we've seen from some of the more recent cases, the Hague case there on the sheet, case 222 of 2015, here there was a call for tender by one party, and they simply referred in the call for tender to their general terms and conditions, which the tenderer could click on, and the general terms and conditions contained the jurisdiction agreement, and when the contract was signed, it specifically referred again to those general terms and conditions, but without specifically referring to the jurisdiction clause. Here the court said, well, that's fine, you're told that the contract's subject to general terms and conditions, it's up to you to read them. So the jurisdiction clause was held to be binding, and this judgment confirms the earlier El Majud judgment, where a contract is concluded through another party's website and is then given the possibility to open that party's general conditions. Now, Kalosh mentioned in his introduction the Saey Home and Garden case, which is a more recent case decided in 2018. Here, the difference between the Saey Home and Garden case and the two other cases I've mentioned was that in the two earlier cases, the contract was concluded in writing, and there was a specific reference to the general terms and conditions. Here we have, in this case, an oral agreement without written confirmation, and the clause is contained in the general terms and conditions. Now, in that type of situation, even if in the oral agreement the existence of the general terms and conditions has been mentioned, it doesn't satisfy the formal conditions, and therefore is held not to be validly concluded. So, and then again we have some what we might call special cases. There's the Powell-Dufferin case, which concerned the issue of whether a shareholder is bound by a jurisdiction clause inserted in the company's statutes. when the shareholder, when he bought the shares, not necessarily directly from the company, but from a third party, may not have consulted those company statutes. Here the court said, well, in these very special circumstances, the shareholder should know that the agreement between him and the company is contained in the company statutes, and it's his own problem if he doesn't actually go and read them. And this is confirmed in a case I haven't put on the sheet, the case of C 366 2013 profit investment, which concerns the issue of a jurisdiction agreement in a prospectus, again where the court rather, I think we can say, although it doesn't rely on Powell-Dufferin, applies the same reasoning. Now, one new factor introduced by Article 25 in relation to the previous versions of the regulation is the rider at the end of the first sentence of Article 25, paragraph 1, where you'll see the words, unless the agreement is null and void as to substantive validity under the law of that member state. Now, well, that member state refers not to the law of the court seized, but the court designated in the jurisdiction agreement. There is no such equivalent in Article 23 of Regulation 44/2001, and indeed the approach that the court had taken, which was simply saying this is what we're looking for, is whether there is genuine consensus, which must be determined according to whether the formal conditions are complied with. This extra clause seems superfluous. Apparently it was inserted simply to bring the regulation into line with the Hague Choice of Court Convention, where a similar clause features. What precisely it means is still a little unclear. It obviously cannot mean that the court of a designated member state may impose conditions which are not to be found in Article 25, or indeed may dispense with the conditions that are set out there. And according to the experts' report on the Choice of Court Convention, all that this refers to are issues of consensus, such as, so it might conceivably apply even where the formal conditions of Article 25 have been complied with, but one party claims that in reality he didn't consent. So to my mind, it's rather unnecessary and has the potential for frustrating jurisdiction agreements, but doesn't seem to have caused too many problems so far. Now, the other somewhat vague requirement of Article 25, which has been causing problems latterly, is the expression, again in the first sentence of paragraph 1, which is a reference to disputes which have arisen or may arise in connection with a particular legal relationship. Now, what does this mean exactly? Now, clearly, if you have a contract for the sale of goods and there's an ad hoc jurisdiction clause which refers to disputes arising from the sale of those goods, then that is a dispute arising in connection with a particular legal relationship. Similarly, you may have the other end of the scale, a jurisdiction agreement between the parties which is not attached to any particular contract, but which says every dispute that arises between us will be subject to litigation in the courts of Germany. And that's, and in principle, the regulation doesn't have any objection to that kind of very widely drawn jurisdiction clause, provided again that it doesn't take one of the parties by surprise. Now, we have here a couple of cases which are quite difficult to reconcile. The first point is that the jurisdiction agreement, it may extend to non-contractual disputes if the parties have made this clear. But we have two cases concerning infringements of competition law. In the first case, the famous CDC case, we had here an action being brought on the part of victims of a cartel, and they were bringing their actions against contracting parties from whom they'd bought goods, but it turned out later that the prices were inflated because the contracting partners, the sellers of the goods, had been party to an illegal cartel. When the buyers who were victims of the cartel brought an action against the sellers for damages representing the difference between the price they paid and what would have been a market price, the question then arose as to whether the jurisdiction clause inserted in the contracts between the victims and the sellers covered this type of dispute. And the court gave, I think what we can say is a slightly Solomonic judgment. It said that in order for the jurisdiction agreement to be valid, it would have to be so specific that it would have to say that it covered actions, disputes relating to liability resulting from an infringement of competition law, which of course is unlikely that this would happen in practice. On the other hand, we have the more recent Apple sales case, where the case with the same rapporteur, where the court distinguishes CDC, where the breach of competition law concerned is not participation in a cartel, but an abuse of a dominant position. So here, one party brings an action against another party to an agreement, claiming, it's not made very clear in the judgment precisely the context, but claiming abuse of a dominant position. One would have thought a priori that CDC judgment would apply, but here the court says that a jurisdiction agreement that refers in the abstract to liability arising out of the contract can cover a dispute when one party is alleged that liability flows from abuse of a dominant position. So in those types of circumstances, if the victim is claiming that he's paid an extra high price because of abuse of a dominant position, then apparently he can be barred from the court that he wants by a jurisdiction agreement. Whereas if he was bringing a similar action against the other party and that the wrong was participation in a cartel, then in principle the jurisdiction agreement wouldn't apply. Now, since we're running out of time, I just want to say briefly a couple of points about the relationship between Article 25 of the Brussels regulation and the cognate provisions in the Lugano Convention, and the potential clash with the Hague Choice of Court Convention. Now, with regard to the Lugano Convention, this, of course, if you're dealing with a case where, say, one of the parties is domiciled in Switzerland, or if you have a jurisdiction agreement that confers jurisdiction on a Swiss court, this will set alarm bells ringing because of the potential relevance of the Lugano Convention. Now, in the circumstances, the Lugano Convention contains a very explicit jurisdiction clause, a very explicit disconnection clause. In principle, the member states of the European Union can apply the Brussels regulation to disputes where there's no connection with the Lugano state. But if there is a connection with the Lugano state, then in certain circumstances the entire Lugano Convention will prevail, or possibly certain provisions may prevail, including the provision on jurisdiction agreements. Because the Lugano Convention is very closely modelled on the Brussels regulation, but it's more modelled on Regulation 44/2001. But I think in practice, if you're applying the Lugano Convention and the Brussels 1A regulation in tandem, there shouldn't be too much potential for clashes. However, with regard to the Hague Choice of Court Convention, there is no quite such explicit disconnection clause. Now, I think my overall message for the with regard to the Hague Choice of Court Convention is don't worry too much about it at the moment, because there's not actually that many contracting parties. Apart from the EU itself, then we have Singapore, Montenegro, and I think one other contracting state. So you're not really likely to be troubled with it in the near future. You can also say that the scope of the Hague Choice of Court Convention is much narrower than that of Article 25 of the Brussels 1 regulation, because there are very many exclusions, including tort or deed claims, antitrust, liability for nuclear damage, and so forth. And also under the Choice of Court Convention, the non-designated court has rather more scope than under the Brussels 1 regulation for not complying with or for not ceding jurisdiction to the chosen court. Also with regard to entry into force, whereas the Brussels 1 regulation, of course, applies to any dispute which is brought before a court in a member state after the entry into force of the regulation, the Choice of Court Convention will only apply to choice of court agreements concluded after the entry into force of the convention for the state of the chosen court, and of course will only apply to proceedings brought after the entry into force for the court which is seized in breach of the jurisdiction clause. But in any event, for cases which don't involve a contracting state to the Hague Convention, which is not simultaneously a member state of the EU, that's really the only type of situation where it is likely that the convention would prevail. So as I say, I think for the time being, the Hague Choice of Court Convention is not really going to cause too many problems for a court in a member state. So on that note, I'll conclude what I have to say, and thank you for your attention.